So clearly it was good. I would have to take much. Yeah. How was it? It was, yeah, I got it up there where it's on it.
Hello, I'll call to order the October 17th meeting of the Salem Planning Commission. Jennifer, would you please call the roll?
Commissioner Augustine, absent excused. Commissioner Pot. Present. Commissioner Goble. Present. Commissioner Griggs. Here. Commissioner Heller.
Here.
Commissioner Levin.
Here.
Commissioner Slater. Absent. Commissioner Villarreal.
Here.
We have quorum. Thank you.
Before we get to the public comment, which we don't have anybody here to comment public, I did want to say just a few things about Commissioner Ekas, and it's just a shock when you get that call. You don't expect it. And he was, in case you didn't know, he was a legislator back in the 80s, and that was during the time that Vera Katz was called the Kids and Cats. Vera Katz ran the House and Kit Sauber ran the Senate, so it was a great time to be in his party. A lot of great things happened. He was then appointed to be the Public Utility Commissioner after that. Retired from that, I think in 21, no, 2000. It wasn't very. But I did some research because I didn't know much about Bhutan, which is apparently where he was hiking. And this gives you just such a great insight into this man's personality. What I read is that in order to hike in the Bhutan, which is a very difficult terrain, very rugged, very steep, that at a minimum you should be able to walk 10 to 12 miles in a day with your loaded backpack up, the ascent. So I just thought that was a great picture and the way that he kind of attacked life. We will miss him. I'm sure council will find a good substitute, but I thought I'd open it up if anybody wanted to say anything just to bring some closure to it for us, but don't feel like you have to. So I will see anybody. Okay, we're all good. We're gonna miss him. I can see it etched on Commissioner Heller's face. So we'll move to item 3, public comment. There's nobody here from the public to comment. Moving to the consent calendar, I'll look to Commissioner Heller for a motion.
I moved it. I've got. What was our last meeting?
It was September 19th. It reads August 15th, but it was September 19th.
I moved that the minutes from this September 19th meeting.
Okay, and do I have a second?
Second by Levin.
Second by Levin. And before we call for the vote on that and discussion, I wanted to see if Commissioner Goble, did you get a chance to listen to that meeting, or would you rather abstain?
I listened to half of it and I'll abstain.
Okay, sounds great. So Commissioner Goble has abstained. So we have a motion, we have a second. Do we have a discussion on that motion? Seeing none, Jennifer, would you please call the roll? Signify by saying aye if you're in favor of the motion, nay if you are opposed.
Commissioner Pot.
Aye.
Commissioner Goble.
Abstaining.
Commissioner Griggs.
Aye.
Commissioner Heller.
Aye.
Commissioner Levin.
Aye.
Commissioner Villarreal.
Aye.
Motion passed. Public hearings, we don't have any. This is just a lovely meeting. Item 6, special orders of business. Lisa, you have a staff presentation on commissioners' roles and responsibilities. And I think your intent is to share this meeting with anybody who's going to apply for one of these openings.
Yes.
To give them an overview. Just to be reminded members. After I go, Brad is going to give this presentation as well. Okay. So I'll just get this presentation up here real quick. It's great if you're really tall. I offered to help, but I would be no.
Waking up the screen.
Okay.
I'm Lisa, for the record, I will be your planning administrator. So I made this training, it's really for people that are new to the planning commission. So I think this will be basic information for all of you, but maybe not, because so I don't think we did a training with Commissioner here, Rendell. We were planning to, and then Fred and I never got together. But if you have any questions, interrupt me at any time, and don't feel like they're dumb questions, because you can just blame me for not having provided it before. So I think this go away, Jonathan. This part go away. This is really annoying. Okay, so to start, the planning commission, your role is defined in a couple different places. First is in Salem Revised Code, chapter 6. What that says is the planning commission is an advisory commission. You're advisory to the council generally for growth and development in the city. If you've read that chapter, is I think probably the original language that was created for the planning commission. So it says a lot of things that are under the purview of the planning commission. Generally, it talks about zones and streets and setbacks and lot standings and uses. It says you're going to plan for the future growth. So generally, our comprehensive plan, our transportation plans, parks plans, that you're going to consider the needs for employment and housing lands. It does say you're responsible for the morals of the city. So if you didn't know that, it's hope you've been working on that. So it's a little dated for that. It also says that the planning commission is our committee for citizen involvement for the city. We're required to have some sort of committee under statewide planning goal 1. Goal 1 is citizen involvement. Over the years, the city's been doing planning. Obviously, we do broad public outreach. So I think in the original kind of days, the planning commission was the one place for people to come and be involved with planning. But obviously, all of our major plans come to the planning commission to ensure that the public has a chance to provide testimony on this. And then a lot of what we do here is that, you know, you're the review authority for certain land use applications or the appeal body for certain land use applications. You were appointed by the city council. I put usually after an interview because I think we were speaking lately, but most of you went through the interview process. And before your term, you reappointed, so you did 8 years. If we're lucky to have you for 8 years. We were just talking about before the meeting started, there are some special membership requirements. We can only have one member that's a non-resident of the city. We're all in the city right now. And we can't have more than 2 members that are principally engaged in buying, selling, and development of the state profit. And then it says we can't have 2 members that have the same kind of business trade or profession, which I don't think has been an issue since I've been on the planning commission. And we meet twice a month, generally, at least once a month. So it says we will. So the planning commission rules, again, I was reading them today. It gives lots of information about how we elect officers, the requirements for attendance and getting excused absences, conduct at meetings, how you need to raise your hand, the president needs to call on you, that kind of thing, what our quorum and voting rules are, how we're going to run the meeting. So if you look at the agenda and the set of things we're going through, that's from your bylaws. So if we want to change the order of agenda permanently, we change the bylaws. It's where we get our time limits for testimony that the president keeps track of during public hearings, and has rules on how to reconsider an item, and then how to suspend the rules if you want to suspend the rules. The meeting is run by our president, President Graves at the moment, who's the presiding officer, or we have a vice president who will fill in if the president is absent, and usually has to make the motion, or we ask them to make the first motion on the cases. And then the bylaws say there's a secretary and it's the planning administrator, which is me or my designee. Most of what we do are public hearings, so I'm going to talk a little bit about the process for hearings. The rules for a hearing are set out in our codes in Revised Code Chapter 300. And that generally comes from the revised statute. There's two sections, 197 and 227, that have rules for how land use hearings need to be conducted. And then obviously, again, we have time limits and various things in our planning commission rules, and we use Robert's rules. Your role as a commissioner during a hearing, you need to come in with an open mind. We're going to talk about bias and conflict in a minute. Read the materials that are provided, but don't go do your own research or site visits. Ask questions in the hearing if you have questions. Don't assume an answer. Allow the applicant or folks that are participating a chance to respond to what your concerns might be.
And
Yes.
Lisa, I think the reason for the don't do the site visit is because then you would come to the hearing with knowledge that the rest of the commissioners don't have. So if you, correct me if I'm wrong, but if you're driving past property to work every day, you obviously are going to see that and maybe notice something. And then all you have to do is at the meeting, just state that at the beginning of the hearing. You have this information, it's not gonna, and that's the conflict piece, right?
Yeah, that would be more like ex parte, and I'll talk about that a little bit more, but that's yeah, don't do your own site research. But you know, you live in Salem, so you don't have to say, oh, I'm familiar with Commercial Street, you know, for every hearing, obviously. So, don't testify in your comments. If you have something that you think is relevant information, try to ask it in the form of a question, so the applicant or the other folks that are participating can confirm that information that it's the same information. And you can only apply the criteria. So we're going to talk about all these things in a little more detail. But first, there's two types of public hearings that we have. The majority of them are quasi-judicial. So that means someone submitted a land use application and they're asking the city to approve it or deny it, asking us to approve it, but we might deny. It's generally a small number of properties. The main difference is we have to issue a decision. So as a city, we get an application, we have to process it. Examples, there's examples on it that don't necessarily come to the planning commission, but put on appeal. But like a comprehensive plan zone changes, a common one that would come to the planning commission. Ex parte rules apply for this kind of case, and I'll talk about ex parte in a minute. Legislative is when there's no applicant. It's a city project that's coming forward. Something like our comp plan, our Salem is legislative, our parks plans, neighborhood plans, or more recently, like 5G code that's come through. Those are all legislative. And that means you can talk to people, you can go do your own research. If you were really interested in the climate, you know, parking lot rules we had recently, and you were just doing research and bring ideas forward, that's totally okay. And you can talk to all the neighbors and anything you want on the legislative. So in a quasi-judicial decision, we talk about it a lot. The applicant has the burden of proof. So all the staff is reviewing it and providing a recommendation that's really on the applicant to show that they meet the criteria. And the decision has to be based on the criteria. And participants have the right to hear and rebut all the evidence and to know that you're an impartial decision maker and to know what criteria are being used to make that decision. There's 4 types of land use applications under state law. Type 1 is not something that would ever come to the planning commission. It's a staff decision, and generally we don't need to provide notice for those to the public. Type 2, we provide notice and before we issue a decision, but it's still a staff decision. So an example is a partition in a subdivision. But those can be appealed to the planning commission. So we've reviewed subdivisions on appeal before. Type 3 are the ones that just automatically come to the planning commission. If you make a comprehensive plan change, refinement plan, Fairview or something like that, we're bringing forward. So that's going to be the most common ones. We do have type 4s, historic designation, which comes to the landmarks commission, not the planning commission. But the type 4s, the planning commission would review would be annexation with the zone change, or we would have the hearing here on the proposed zone, and then the council would determine if they want to approve the zone change and annex the property. So those kind of applications have 2 things. So ethics. And I copied this from Natasha Zimmerman, our former attorney. So, but Friday's here if you have more detailed questions on conflict of interest. But according to her slides, there's 3 common ethics issues: conflict of interest, ex parte, or improper use of public office. I'm not going to cover improper use of public office. Generally, you don't have any city resources at your disposal, so it's not necessarily something that would come up. here very often. You are subject to Oregon government ethics rules, and the city has our own ethics board, and you're solely responsible for complying and being ethical. It's not a city responsibility. So first is a conflict of interest. You have actual conflicts, and that's if that any case or decision that's before you would have a benefit or detriment to you, an actual benefit, generally a financial benefit. It would affect your business, your family's business, or something like that. That would be an actual conflict of interest. A potential one is that it may or it may not, but it's not clear that it's going to, but it could affect you or your family in a case. If you feel like you have an actual conflict, you need to disclose the conflict and remove yourself from the decision-making process. And generally, we would ask that you actually get up from your seat and go sit in the audience. So it's very clear that you're not participating in that hearing. If you have a potential conflict, you need to disclose it. And if you feel like you can still participate and vote, then you can do that. If you're not sure, you can contact the Oregon Government Ethics Commission for advice. You can talk to Fred, but the city will not give you legal advice on your ethics, but might tell you they think it's a good idea to contact the Government Ethics Commission. And I know some of the commissioners here have done that process in the past. So ex parte is any communication regarding the substance of a land use application. So again, not legislative, but in this quasi-judicial world, any kind of communication. And it can be like reading an article in the newspaper, but more likely is an email, phone call, neighbor talking to you, people talking to your friends and family, because they're on planning commission. And it can even be when you don't respond. So I know this happens to the counselors a lot. They get an email and they read it, and then they have to read it to know what's about the land use case, and then go, oh, well, that's ex parte, but I didn't know until I read it. So you maybe don't know until you already received that communication. You can't necessarily avoid it. So why does it matter? Ooh, that doesn't look great on the slide. So why does it matter if you have ex parte communication? So during quasi-judicial, you're really decision makers, kind of like the trial or a judge. Everything that you're using to make a decision, everyone should have that same information. So it should be from the staff report, from the materials that are submitted, from the testimony and the discussion in the hearing. And that goes for the applicant or appellants or neighbors or anybody on any side. And everybody should have an opportunity to hear the evidence and arguments, address those concerns before you make a decision. And you just generally want to avoid the appearance of a bias or prejudgment for any case. So ex parte applies to you as a decision maker. It also applies if you may review an application. So as I mentioned before, there's some land use applications where you are an appeal body, and we don't know at the beginning of the case if it's going to be appealed. If it will be for the planning commission. So generally, I would say just probably don't talk to people about land use at all, because it might come before you. You can if you, I think this slide says, when does it apply? Oh, I should start there. So it applies the moment they submit a land use application, which will be long before it gets to the planning commission. So sometimes the counselors will call and say, somebody's wanting to talk to me about this issue. Is there an application on file? Because if it's not on file, it's not ex parte. So you can always ask me. If you do participate in ex parte and it's not disclosed, it could result in a case being reversed or remanded due to that non-disclosure, because somebody can make the case that you had information that came to you outside of the hearing. And I'm not ex parte communications. You can always talk to staff, any city staff, me or the planner or the public works staff or anything like that. And obviously we talk to the public, we talk to the applicant, etc. I think I have a slide on what to do. Yes, finally. Here's my slide on what to do. So generally we try to tell you to avoid it if you can. But again, you live in Salem and you know lots of people and they probably know you're on the planning commission. So you can, for example, if it's an email, somebody emails your personal email, you can forward it on to staff and we would include it in the record for that case. So that, and then provide it with like regular testimony. We can also respond to the person on your behalf if you would like us to. I do that a lot for counselors and respond and say, this is the process, come to the hearing, or we're going to include this, but we're not going to respond to you. If it's your friend, you probably don't want to ghost them. Happy to respond to them, but if it's someone you don't know that well, I'm happy to do that. At the beginning of the meeting, you would want to disclose any ex parte contact that you had, even if you have already forwarded the email or if it's a conversation. And you would want to disclose that you think you can still make a unbiased or impartial decision despite that contact, assuming that is the case. Anybody have any questions on ex parte before I move on? No. So for our hearings, we do have conduct of hearings in the code. This comes straight from the Salem Revised Code. And you're all familiar because you sat through a lot of hearings now, but at the beginning, there's always going to be a disclosure statement that Jennifer will read, which is going to list the criteria. So again, that everybody knows what we're considering when making a decision, how to appeal it generally, and that, you know, you got to raise it now if you think it shouldn't be before the planning commission. And then the president's going to call for ex parte contacts or conflict of interest disclosure. So that'll happen right at the beginning. If we're down the road in a hearing and then you realize you have some sort of conflict or something, you can always raise your hand at any point. I'm sure President Griggs will call on you, and you can declare it later in the meeting. It's better to say it than to think, oh, well, I missed my opportunity and not say it. The conduct of the hearings are generally going to be with staff giving a presentation, and then the applicant, and then persons in favor, neighborhood associations, persons opposed, other interested persons. The hearing is always going to end with a rebuttal opportunity for the applicant. That goes back to them having the burden of proof. Because they have that burden, they get more time to talk. So they get the last word, basically. And this comes up a lot here at the Planning Commission. So before the hearing closes, if anybody that testified asks for more time, the Planning Commission is required to provide that time if it's the very first time that the case has had a hearing, which most of the time will be what's happening at the Planning Commission. But you do have a choice between continuing the hearing or leaving the written record open. So if we continue the hearing, we delay deliberations, we delay a decision to the next meeting, and you just make a motion that you're going to continue it, and it's just like in the next meeting or whatever date we pick, we're just going to pick right back up with that hearing. You can accept testimony again and ask more questions of staff. The pro, I guess the con for that is that people can come and testify again, maybe tell you the same thing they told you in the first hearing. But the pro is that more people can testify verbally than didn't get a chance the first time. Or maybe the applicant's wanting more time to address, change something in their application to get a favorable review, and they might want to continue it so they can submit that and then answer questions about it. I think generally the Planning Commission, though, what we do is we close the hearing and leave the written record. We generally do a 7-7-7, so 7 days for all parties to provide new testimony, and 7 days for anybody to provide rebuttal. And then again, the applicant always gets the final word, so they would last 7 days. And then so generally, since we meet twice a month, we would decide about a month. When we do that, the hearing is closed. We come back to deliberate. No questions about it. We're done. Either way, if this happens, we still have to comply with the 120-day rule. So under state law, we do have to issue a final decision within 120 days when we deem the application complete, which includes appeals. So if it's a case that is not on appeal at the Planning Commission, but it's just the Planning Commission hearing the case, you have to remember that generally they can be appealed to council. So we have to leave a few months for the council to have their own hearing process. Only the applicant can extend the deadline. They often do. If it's in their interest, they don't always. They control that. What staff can control is scheduling the hearing quickly from the time it's being complete and trying to get it in front of you right away so that you have plenty of time to deliberate or have more than one meeting. If we don't issue a decision within 120 days, which has not happened the entire time I've been planning administrator, they can file a writs, I think it's in circuit court, and get a decision and potentially not have all the conditions on there that we might want to impose, might get a decision that we wouldn't have wanted to issue, and can potentially ask for us to pay their attorney's fees. So it's not something the city would want to do. For deliberations, we always need a motion to get that started. That goes back to our vice president. who's kind enough to generally start with a move staff recommendation motion. Even if you know it's not what you want to do, ultimately, it's a good motion to get the conversation started. And amendments can be offered. We only allow 2 motions on the floor at a time, right? So 1 amendment, vote on that up or down, and then go from there. You can ask questions of staff during deliberations, but we can't introduce new evidence, so we have to be careful in our answers. But sometimes, and I feel like this happens a lot, Historic Landmarks Commission, and not so much at Planning Commission, during deliberations, they always think of more things they want to know, and only the applicant holds that information. Staff doesn't know, and so they have to have a discussion about if they should be reopening the hearing and allowing the applicant to come back up and answer those questions. It is possible to do that, so if we get to that point in deliberations, we can discuss that, and by motion, I think we can move to reopen the hearing. And as long as the applicant gets their time to have their last say again. We can do that. And then the public can't testify or communicate during deliberations, so the hearing's still closed. That happens a lot at council. People shout out from the audience. Somebody ponders something in deliberations, and there's always somebody in the audience that doesn't know the answer, so mayor usually has this. Yeah, we'll know. Again, we're always going to evaluate the proposal against the criteria. This example of our notice, we put the criteria right on the notice. And we always address it in the staff report. Sometimes I know, especially Planning Commission, we have 6 or 8 applications combined to one. There's a lot of criteria, but we do go through and address all of them. Sometimes folks can say we've missed a criteria or something that applies, so staff will have to review that and determine if that's accurate or not, and if not, address why that criteria didn't apply. And then generally things that we bring to Planning Commission, we have proposed staff has proposed conditions of approval. We're allowed under state law to provide conditions of approval. They have to be for a planning purpose. They have to allow the application to better meet the criteria. So it can't be just that you really want them to do it. You have to be able to say that there's a deficiency in their application when you look at any particular criteria or standard, and the condition will help them get there. Sometimes they're really easy. Setback is 10 feet and they only show 5. You have to put a condition that on your building permit, you have to move it to, to meet the setback. Sometimes it's not so clear if it's helping them meet the criteria. And we also can't change the nature of an application. I know we've had this a lot for zone changes where they come with a zone and then through the hearing, we're like, boy, a different zone would have been better. But at the end of the day, we have to issue a decision on what they're asking for. So it's a yes with conditions, or a no. If it's a no, they might hear a lot that the Planning Commission decided a different zone through, is more supportive of a different zone. They can choose to amend their application, but we can't change their application. And then lastly, the night that you vote, that's not technically the final decision. Chain reviews the documents the next day. Generally, we get them to her the next day, and then her signature is added, and then we mail them out. We have up to 7 days for that process. And so it's not a final decision until it gets mailed out. And then there's ex parte during that. If it's one that's appealable to council, then obviously it's not done until we know it has not been. That's all I have in my training. Questions?
Anybody have questions? I think you covered it.
Great. Well, then I'm going to have Fred come up, and he's going to a couple different things. But I can make it work. Wear my glasses and you can see. Just have to share it so the folks at home can see. Screen. Here. Go. Okay. So.
Okay.
But I'll say.
All right, great. Hi, y'all don't know, I'm Brett Wilson, Assistant City Attorney. I really wish I had go on first now because Lisa's was so good. Mine seemed terrible by comparison. Hard to follow. Yeah, so I've got a couple of handouts that Dan put together, city attorney. I think you probably got these when you first joined the commission. So you probably heard all this before, so it's kind of a refresher. If anybody has any questions, feel free to jump in at any time. I'll probably go through some of it quick because you know, and some of it doesn't more apply to city council stuff, so we won't go through everything that's on there. And I was going to make a joke that there's going to be a quiz at the end, so pay attention, but Dan actually does have a quiz at the end. But I won't make it to it. Okay. So this is just a statute. Nora asked why we have to have public meetings. I think we all know about that. The policy and the purpose behind these are just that the public's business has to be made or discussed out in the open. One of the things we have to do is make sure the public has notice the time and the place, and that we have to make sure it's accessible for everybody to get here, which I think we did a good job of. Those are sort of the key requirements. It's kind of the same thing. We also have to take minutes of the meeting. So we've got a new person on board for that. So far, so good. Who is subject to the public meetings laws? And again, this kind of goes to all the different bodies in the city, but the planning commission definitely is. So we have to abide by all of the requirements. This is more about us being subject to the laws. Like Lisa talked about, if you're just dealing with staff, that's not something you have to worry about. Neighborhood associations, they're not public bodies, so they don't have to go through the laws, so we don't do worry about them doing that. What meetings are subject to law? Meeting is the convening of a governing body for which a quorum is required in order to make a decision or to deliberate a decision on the matter. So whenever we have a quorum, that's when we have to abide by the laws. I think we talked about that earlier about subcommittees or meetings, so we have to be careful that it's when we get together, we don't accidentally get a quorum and doing things not meeting the requirements, which can get us in trouble. Now that we have a smaller number of people, maybe be extra careful that we don't have like a subcommittee of 4 getting together right now, because that might actually foul the laws. So we don't do that. That's sort of what we were just talking about, was meetings are not subject to the law. So if we have less than a quorum, okay, on-site inspections, although we just talked about, we're not supposed to do that. But sometimes other bodies sometimes do things like that. Social gatherings obviously are not subject to public meeting laws, and you have the retreats, goal setting sessions. So I don't know if you guys have those. And then this is there's a couple of cases that happened in the past where governing bodies or county commissioners didn't realize they were doing things that actually qualified as meetings that needed to be subject to the public openness requirements, and they got in quite a bit of trouble. So Dan was obviously very worried about us doing something like this, so we got a lot of slides about this. But they're called sort of serial meetings. So we had Board of County Commissioners just sending email after email after email, and eventually all the Board of County Commissioners were responding and involved. So it was almost like having a virtual meeting. And so, of course, they didn't realize that didn't abide by the public requirements like notice and open to the public, that kind of thing. So they got dinged for quite a bit of damages. So they definitely doesn't want that kind of thing to happen. Here's just some of the lessons from those cases. Use of a personal computer and a private email account to conduct a public business may subject your personal computer or private email account to disclosure of public records request or litigation. So I think we've talked about when you're using your phone or just your home computer, make sure you use the public. You have your planning commission email versus your private email. So I don't think we've had any trouble with stuff like that coming up here, but if it did, the last thing you want to do is have your your personal phone being subject to discovery or public records requests. This is also just if you have a quorum doing it by email, you can get in trouble again. And one of the standards in that case is that you have to have willful misconduct. So be careful not to violate requirements. Dan's made the point of that, ask one of the attorneys, and if we give you advice and say it's okay, that's much more likely that it would be okay for not to willful misconduct. This other decision, Lane County, they kind of got in trouble by doing reply all to the county commissioners, so that's how they brought everybody in. It shouldn't have. This is the case. We don't really do executive session with Seaver, so let's skip that part. And then here's where we get to Dan's quiz, so we won't you guys go through this. We have these presentations, so if anybody wants us to email them to us, they have their own copy, of course we can do that. So the grand takeaways are local government is not a state legislature. Public has the right to watch the sausage get made. Be very careful about serial meetings that can be personal liability for y'all and also the city. And then Dan's advice to always follow the advice of your friends. So that is the end of the Oregon Public Meetings Law presentation.
Does anybody have questions? I do know the legislature does have to abide by the public meeting laws too. Even though they can go into executive session. Any other questions?
I think that one was, we had one on parliamentary procedures too, so. Yes. And this is a lot of the just Robert's Rules of Order stuff, and obviously President Briggs knows, she knows this better than I do, so I don't have to tell you guys much, you do this so well, but some of the basic principles of this are the purpose is to provide structure, facilitate orderly meetings, protect the rights of the minorities to be heard. And a lot of the reasons you need like Robert's Rules of Order, specific stuff like that, like in the US Congress, you have people who are really, at odds with each other. It's kind of important to have kind of rules, more fair in here. And here it's everyone seems to get along a lot better, even if you have differing opinions on how to decide a case. We don't sort of have that kind of fighting, so it's more just to kind of give us a structure for doing it. It's not so much to separate combatants. The most important thing is that it's clear what we're doing. So we don't have to be super sticklers to the rules. We try to do it that way, but I could be wrong, I don't think there's ever going to be a case where like there was an argument decided that somebody violated Robert's Rules of Order or something like that. So this is just sort of a way to help us connect with. So we did President Grace. Work really smoothly. So some basic principles is we talked about quorum a lot today, having a majority. We talked about this a little bit before the hearing, that if you've got less than a full complement of whatever we're here, commissioners, like typically you need 5 to have a quorum, obviously. But if you're down to less than 9, if you have 8 or 7, we talked about this, and sort of the general consensus is you just need a majority of how many members you actually have. So if there's 7 planning commissioners actually seated, the quorum would be 4, you wouldn't be 5. And then when it's time to have discussions, there's a motion necessary to initiate it, and Lisa talked about a lot of this as well too. And here we need a second to do that. There's sort of the stickler rules is only consider one motion at a time. You only get to 2 amendments to the main motion. Otherwise, you have to vote that one up or down and start a new one. So the basic principles is obviously only one person can speak at a time, and we've got fancy microphones to make that happen. Sometimes we can't have the one person talk. To speak, President Grace has to recognize you to speak. And then again, a majority vote form decides the matter. And as we talked about at the beginning, you have to have at least 3 people voting to have something passed. And then I think you guys all know this, but to how to make a motion, we've done that. How to second a motion, I don't think we have any issues on that. Presiding officer states the question, it's time to take a vote, which on the floor is yada, 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 so. And then here's the thing, once the motion's been seconded, it's sort of out there to the commission, you know, the person who made the motion can't withdraw it. I mean, sometimes maybe somebody changes their mind about what they want to do, so let's just withdraw and technically do it. Once it's been seconded, we need to vote on it, so we're ending. Just sort of the nuts and bolts of once the motion gets made, maker of the motion, obviously it's the first opportunity to talk about it. If anyone else wants to talk about it, President Griggs will recognize them. If nobody wants to talk about it, then the President Griggs will just call the question. And it's all those in favor, after she says what it is, we'll ask for votes. Obviously you have to be here to vote. And then if it's a tie, it fails. Some of the common motions we have, obviously, we have the main motion. It's been seconded and debated, amended up to 2 times. Motions to amend. If we want to, I think we did this fairly recently. I think that was historic landmarks, but if we want to make a motion to put this off to another hearing, we can do that for to a time certain. It's always best to, if we are going to continue a hearing, continue it to a time and date certain we announce. That way we don't have to renotice it. If we just say we're continuing to some point to be determined later, then we have to resend notice. We don't want to do that. And then if we're deciding whether or not to defer it to a later date, the kind of discussion about that should just be about whether we're going to move it to a later date, not about whether the motion itself, you know, whether we should approve or deny something. The actual application. Yeah, there's motions to reconsider. The one little twist there is if you have to admit a majority, if you want back and it's to come back no later in this meeting. Don't know if that's come up here too often. That happens in the council more often. There's motions to suspend rules. Again, I don't know if that's not very often here, but you would do that. It takes 2/3 of the majority present, and you can't suspend things from the code. Point of orders is just somebody wants to, it's not a motion, but it's just to talk about a particular how the rules work, basically. Here's the next quiz. We'll give everybody a just to move along. So if anybody has any questions, I'd be happy to answer them and happy to send this along to anyone wants to have this just in case.
Thank you, Fred. Any questions? Not good. And whoever gets to have this seat and be in seat after the end of December, you've got 2 people right here that will walk you through, like if you forgot to do something, which was probably the first 5 years of the city. Pretty sure. Okay, that was around the information reports, and we don't have any. We have no subcommittee reports that I'm aware of, right? Planning administrators. What? You're second. That's fine. Yes.
Well, last night we did have the volunteer recognition. We sure did. So Ben, President Grace, received an award. You can tell she's very happy about it. Very Commissioner Ben was there, and Commissioner. I saw you at the beginning, and I never saw you again. Did you stay the whole time?
But we saw each other in the park. We did great.
Because Kimberly's like, I saw Chris. Where did he go? And I was like, I saw him with Commissioner Bob. I don't know. Anyway, Commissioner Zimmerman from the HLC also received. So we prepared for that, and well-deserved award.
Yeah. Okay, what's the next part?
It was great event. It was a great event. Next, November 7th is our next meeting. We don't currently have any items. It's an election night. And I don't think we're gonna have any staff items, maybe today or tomorrow is the deadline, yeah. And so it's up to the commission unless you have subcommittee items you would want to put on there, otherwise that meeting can be canceled. We do have the hearing on the 21st. Oh, yeah, be thinking. Elections will be our very first meeting in January, so for those of you, we're gonna need a new chair.
You guys be just
And
talking, don't
vice
have
chair.
more, but talk to each other, you know.
And normally it's the vice chair that moves up, but our vice chair is terminated as well, so we're losing the chair and the vice chair, so we're gonna need 2 new people to run this meeting.
Sure will.
And yeah, I think we're, please drum up, people, applicants. I think the city's gonna do some social media, posts about it as well, and I will try to ask the mayor's assistant when they're gonna review applications. Maybe they'll do it in December and we will have a vacancy for a long time. I don't think any of the subcommittees will still have to form them. We'll have a quorum, right? Because what I was saying is none of the subcommittees should be meeting with 4 members after January if we don't have our vacancies filled, but I don't think anyone will expect.
Any questions for Lisa? Thank you, Lisa. Commissioners' comments for the good of the order. Any comments? They're good and orderly. No, we don't have any either. Oh, Ian, sorry, Commissioner.
Well, I've been thinking about Fred as we've been sitting here, and I feel like I just want to say something because your story about his hiking in Bhutan, and I don't know if there's a better way to go than doing something that you really enjoy, and I find that actually pretty rad, which I mean, it's a little morbid to say, but it's pretty rad. Most of us don't get to enjoy life that way.
Right,
So a lot of respect.
thank you. And he's got to be pretty happy because I think Salem Heights is getting some work done in that red right street.
Yeah, he worked for 3 years on the alignment and the council.
So he's did a great job.
And I think Bhutan is the happiest country in the whole world. I know for being happy. There you go. So that's the place to go.
Thank you for giving him flowers. Okay, any other comments? Okay, moves to item 11, which is public comment. Sir, did you have any comments that you wanted to share, or are you just kind of watching the show?
Just want to be involved, and so just want to learn. I know I learn a lot from anybody who is already involved. So I just want to participate, so I'm just thankful that you guys are busy. For sure.
Hopefully we'll get busier.
Right.
Okay. With that, we're adjourned.